Talk shoes. Recorded live.
Hey, everybody.
Well, greetings. Can you hear me?
Hey, Angela, you still having headset problems?
Here's that way. I'm having headset problems.
Ain't bought a new one yet.
No,
Yep.
not yet.
Barely hear you here now.
Go ahead.
Well, hopefully. Well, what I wanted to talk today was about mortgages and Truth in Lending Act. However, from 2 weeks ago, I wanted to offer anyone who had a question 2 weeks ago and wasn't permitted to ask, if you'd like to ask the question first before I get started, would you, click in and let Angela know that you want to ask a question?
Hello, can you hear me?
Yeah, I hear you fine. Did you hear?
Oh, good.
Did you hear me?
Yeah, I heard you. I just want to tell everybody my.
Yeah, I think it's Angela static.
Might not hear me, but I will unmute you.
Okay.
Hello?
So, does anyone have a question that they want to ask before I get started?
Guess not.
Okay. So, what I wanted to share with you about your mortgage contract, besides the fact that you didn't read it, the Truth in Lending 3-day right of rescission that you didn't take advantage of only dealt with the bank assigning you the debt. It had nothing to do with the asset that you deposit to the title company that paid for the house and paid the seller. So you could have done a 3-day right of rescission and not accepted the debt, and the house still would have been yours. And most people don't realize that because they didn't understand that the debt and the asset are separate. So they feel if they did the 3-day right of rescission, they would have to give the house back, which is not true. The 3-day right of rescission is not accepting the debt that the bank is putting on you when they fail to do their part, which is this in exchange for this loan that they're going to hold your note, which they don't do. So now they're holding your assets, and they haven't performed their end of the agreement. So you have a right to ask them to return your assets to you because they're making money off of your assets. It says in exchange for a loan. So if you were never given a loan, then it's a void contract, and they fail to perform their end. And so often we don't realize that we have a right to go in and correct mistakes. Attorneys, when they come to court, they make up stuff. The reason you know, because they weren't there. So what are they talking about? Why are they there? Why are they talking, period? They weren't at the closing table. They can't testify to anything, and you're going to let them talk? The only person that knows your business is you. Unless they can round up everybody that was at that closing table to come in and be a witness, nobody else can rebut anything you say. Now, the fact is we need to say stuff by affidavit because they cannot do an affidavit. Again, they have no personal first-hand knowledge, and they're not an eyewitness to the transaction. I created an affidavit of no loan given. You were there. Write the bank a letter and ask them for a copy of the front and back of the loan check that you were given. Ask them also to give you a copy for the note that you tendered. They can't do either because they weren't there. The only way they can give you a receipt for the note, they had to be present. Of course, they have the note, but they weren't the ones present when the note was tendered. Only the person that was present could give you the receipt. So if you ask them for a receipt and you ask for a front-back copy of the loan check, now you have prima facie evidence by affidavit that there's no debt, there's no obligation on your part, and it's a void contract. Now, what the attorneys are doing for the bank is it's called service fraud. And it's a lot of very good information on YouTube about service fraud. They're bringing fraud on the court, and they're willfully exceeding the court into fraud, and you can make them pay for that. Because now they're violating your fundamental civilian due process, which is a priceless right. All your God-given rights are priceless. So, and rather than do a lien on their possessions, you do a writ of attachment, because whatever they possess is not equal to the violation of your priceless right of due process. And I encourage people to study equity, to learn how to use ecclesiastical law for your benefit, because attorneys are not allowed to talk in equity court on the private side. Just like the judge don't want to hear from you on the public, the chancellor will not hear from an attorney on the private side unless you neglect to strike whatever the attorney's trying to present. Because corporations cannot be heard in the private, only flesh and blood people. And that's very important for you to know where your rights are. If you are a people and not a public enemy operating under the Trading of the Enemy Act and the Emergency Bank Relief Act of 1933, the Trading of the Enemy Act was done in 1917. These are things you need to look up and read and redo your status to claim your private citizenship. Because people are private. The all-caps name which they created, that's the public enemy. And you're not that entity. So I want you to learn how to go back and correct your mistakes. It's never too late. Even if you've already lost the property, you can go back and redeem it. Your right of redemption is also priceless. You have a 3-day right of rescission, there's a 3-day right of redemption, and there's a 40-year right of redemption, which nobody ever talked about. To let you know, it doesn't matter when you lost your property. There's no statute of limitations on fraud, and that was fraud by concealment. They didn't disclose to you your right. They didn't disclose to you that it was a trust agreement. They didn't disclose to you that they were never going to give you the loan, that they were going to take your note, destroy it, bundle it together, turn it into a bond, and put it to trade on the international market. Well, that's money laundering. So that's unjust enrichment. You're entitled to get all your assets back, the note, the deed, all the payments plus interest, any money that was hypothecated. Those are called credit assets. You're entitled to, demand that back. And equity will see that, you'll get it back, because equity deals with good conscience and good reason. And equity always does what's fair, just, and right. Equity deals only with the truth. So you always have to go into equity with clean hands. And the bank or their attorney can't do that. Because the attorney is a DBA. He's doing business as an esquire. So he represents the corporation. The bank officer represents the corporation. They cannot be heard from unless you sleep on your right and don't strike everything they say. Just move to strike, move to strike, move to strike. And the pen truly is mightier than the sword. If you write the right letter, you're going to get some action, especially when you let the law firm know that I'm going to take everything you own. My Constitution man used to say, bank, business, and home. I'm taking it all for the unjust enrichment. So, Angela, do you have a question? I can't hear from you. Well, does anyone else have a question?
Hi, Trvth. This is Renee in Texas.
Greetings. How are you?
I'm good, thank you. How are you?
I'm wonderful, magnificent, marvelous, and splendid.
Yes, you are. I have the foreclosure that's occurred already. No detainer yet filed, and I had filed a case on the day of the foreclosure, so I got a case in. I had to rapidly put that together, so I've since made an amendment. The attorneys are denying everything, and I had requested an ex parte on my amendment. They convinced the court to hold a hearing, which is set for next Friday. I have not heard ex parte anything back. I feel I'm dropping the ball.
Okay. First question: Did you type your request for the amendment in ex parte?
I did not. I just put it in the amended complaint. I did put ex parte on there, but I think I shared with you. I also hit them all up with the 4409, the taxes due, the fiduciary duty. So they're not too excited.
Okay, but this is the question I'm asking you. Is the letter typed on a computer, or did you handwrite it?
No, I did not put the letter together, no.
I didn't ask that. That's not the question I'm asking. Is the letter typed or handwritten?
There is no letter. It's just I'm talking about the amended complaint.
Okay, let me rephrase it. I misspoke myself. Okay, the amended complaint is typed. Am I correct?
Yes.
What I'm trying to get you to see, when you want to go to the private side, you have to handwrite it.
Okay.
It cannot be typed. It cannot be typed. And you give it to the clerk of the court, not the judge's clerk, the court administrator, and you request an ex parte hearing with declaratory and injunctive relief.
Yes.
But it has to be handwritten. And the only way you can do that if your status is correct, that you're a private citizen. There's certain documents that you have to do. You have to have a revocation of the power of attorney that you signed, the limited power of attorney that you signed at closing. You have to have your oath of allegiance, and you have to have your copyright.
I do have the copyright and the revocation, and I don't have the oath.
Okay, well, you need an oath of allegiance to the United States and the unanimous declaration of independence in whatever state you're in. Which,
okay.
I can, for a $50 donation to Angela, I'll be glad to give you the template.
Okay, great. Excellent. I'll do that.
All right.
Thank you, dear.
Yeah, email me a copy of the receipt once you make the donation, okay?
Okay, sounds good.
All right.
All right. Take care. Bye-bye. Thank you, Angela. I know you're going to get on here. Apparently, everyone, if I'm still, I just pushed *8, so if you're in the queue, push *8, and Angela will unmute you if you have a question.
Thank you so much.
Okay. And
stay tuned because I have some good, I have a couple of YouTube things I want you guys to look up. And it's just for your information and for your consideration. I want you to look up exiting. You know how you leave exiting Babylon for May 1st. May 1st, 2017. I think you'll enjoy. That's a good listen. And I hope you understand what they're trying to tell you.
I have seen that. Yes, thank you. And I will stay tuned.
All right. Thank you. Greetings.
Hi, this is Greg Kazoo. I wanted to put my hand up because you had mentioned the Trading with the Enemies Act, and I had just looked at that again today, particularly Section 7E, 40 Stat 418 7E, and I like the verbiage there, what it's saying in that particular section. Now, would you recommend? I've heard a couple people say this, and they've had success with it. One guy, he didn't even know what he was doing at the time, but he just put "paid to the order of the United States" on top, on the front page of his mortgage as before he had signed the bottom. And when they ended up trying to foreclose, it didn't go anywhere because he had assigned that to the United States. So I don't think they'd be able to negotiate that as far as a collateral item under the Federal Reserve Act, Title 12, Section 412. Tells you what they're doing. They take your deposit, they use it as collateral for a purchase money contract, and collateral is required, and the collateral being a promissory note or a bond, and it goes on to this big, huge list of all the types of collateral they accept. And another story that I heard from a guy, he put that on the back as an endorsement, paid to the order of the United States, pursuant to 40 Stat 418, Section 7E, as an endorsement, and signed it. And what happened was a couple weeks went by, and he got a letter from the Treasury, because I guess he was the principal on the note. They just basically cashed it and sent him a check, a Treasury check, to him for the amount of the mortgage, and then he just did the same thing again, paid to the order of the United States and sent it right back. And I'm wondering if you would suggest people maybe using the Trading with the Enemy Act on the document itself.
No, I wouldn't. But if what you say is accurate, I wouldn't suggest it because I use a totally different method. There are other ways of discharging debt, and I'm sure you know there's more than one way to skin a cat. If that works, then work it. I'm not going to tell you not to do it. If it works, then you should by all means do it.
Right. Well, I just wanted to get your thoughts on that because I don't have any mortgage or anything. I don't plan on getting. I don't really want anything. As far as
you'd be surprised if you do have a mortgage. If any time someone is holding anything of yours, the insurance premiums are mortgages, car loans are mortgages, student loans are mortgages. You'd be surprised. Don't just think of a mortgage dealing with property or houses.
Right.
You understand?
Yeah.
Okay, don't limit it to that. Just like everything is a trust arrangement. Anytime someone is holding your property, well, other than the note, they have your application for the loan. That's an asset. The bank had a credit account set up for the exact amount of the note.
Mhm.
So that's collateral. You also paid a down payment. You also paid for appraisals. You also paid closing costs, taxes, insurance, et cetera, et cetera, et cetera. That's also collateral. You have about 30 different trusts in a mortgage contract, and they're listed on the HUD-1 statement. All the different trust agreements and arrangements you've made that they did not disclose to you, that's what you were doing. Now, when you fill out an application, don't they keep the application? They're holding something that belongs to you. So now you can make it a deed absolute and turn it into a mortgage.
Okay.
And you can make them the subrogee and you become the subrogor. Am I making sense?
Mhm.
Okay. So anytime anyone is holding something that belongs to you, they are automatically the trustee. They cannot disclaim the trust because they have your property.
Yeah, right. And I like what you said before, that you just put on there, this is trust res. Like, if you know you're not going to get it back, like an application, you know, you may want to let them know that you also know this is trust res, and they're the trustee because they're the ones holding it.
Right. And ask for a receipt. Start asking for a receipt for everything you sign. Because as long as your name is on it, it's your property. And if someone else is being custodian over your property, they are the trustee. And they cannot disclaim the trust, as I stated, as long as they're holding your property. Now, what you can do is turn the paper sideways and down the right margin. Put special, private, and priority. That keeps it from the public.
Interesting.
You can go back and get your hospital records that your mother filled out when you were born. That's her property. Okay? My mother happens to be deceased, so I'm going to say it for me. So I can write my birth hospital. They have to go into the archives and return all the paperwork that she filled out to me, because it was not my mother's intention to make my birth a public announcement. It was a private family matter.
Right, and that was never disclosed in the first place, too. You know, they kind of just do that on the side. After they coerce you into signing it, then the newspaper gets called out and everything, and the announcements and all that stuff. So they never really tell anybody that's what they're doing.
Exactly.
They just go ahead. Yeah.
But the beautiful thing is, once you come into the knowledge of the truth, what the scriptures say, know the truth, and the truth is going to make you free. So let's go back and correct the mistakes. Don't leave them there as they are. Go back and correct them. Demand your property.
Right.
And at least, go ahead.
At least letting them know that now you know that you have been studying and that you know something maybe you're not supposed to, it may frighten them into acting according, you know, like.
It's not that. You're not trying to intimidate them like they intimidate us. You just want to let them know you're holding my property without my knowledge and consent. So I want all rights, title, and interest returned, to me. It's like when they bundle the mortgages and they send them overseas. Well, no one told you that that's what they're going to do. So now they're making money overseas. You can get the IRS, believe it or not, the Department of Treasury, And the Bureau of Public Debt is also known as fiscal services. And I'm saying fiscal, F-I-S-C-A-L, fiscal services. Make them the fiduciary to go after that money that was sent out of the country that you weren't aware of, and have them go collect it for you, bring it back to you, form an LLC, and put it into the LLC, and they'll take care of you for the rest of your life.
Mm-hmm. Yeah, I remember looking at the Bureau of Public Debt works closely with the Treasury Department. When you open an account at the Treasury, if you already have a minor account, you can notify the Bureau of Public Debt that you have a master account, and then ask them to transfer your funds over, if there is any, from your minor account.
Well, there are, because there's a website that you can go on there and put in your Social Security number, and they'll let you know every corporation that's making money off of your Social Security number. And I had like 574 corporations I knew nothing about. So this is what I did once I came into that knowledge. Like I said, you want to do revocation of power of attorney. You want to do a copyright. You definitely want to declare your status so there's no question. And do a notice of interest because that's your property. So the property's not abandoned. But before I had come into the knowledge of trust law like I am now, I was doing a termination of guardianship because each presidential administration administers your trust. And I'm sure you've heard of the Statutes Act of 1666. Mm-hmm. So every president from the time I was born, so I go back to my birth year, and the president then until the present administration have administered my trust. Now I need a termination of guardianship because I'm of age. I'm of the age of the majority. I'm not dead, that I'm alive. And when the true beneficiary shows up, all administration ceases, and have them do a full accounting. And all the money that was made off of my birth certificate and my Social Security number, they have to give it back to me. But it's not cash money. It's private credit. So you can't put it like in a public bank account. That's why you want to form an LLC, a private corporation, and let the judge assign you a trustee. And they will take care of all your needs, your life maintenance, as long as you live. They will take care of all your needs. They'll buy your houses, whatever you need. You just submit a request, and it's done.
Right.
But it's not cash money. It's not Federal Reserve notes. It's whatever type of conversion or credit money that they use. So that's how it operates on the private side. Right. And I sent that information out. Angela put it out in February when I did the calls in. And it's in Christian Walters with Professor Drew. It's in that conversation pack.
Yeah, I remember that. I looked at some of that stuff. But,
right, because you're the beneficiary.
Yeah. Right. They're setting up these life annuities. It's what they always used to say. We need to invest in the children. And this is what they're talking about, setting up these trusts and count. They're gambling on nobody ever finding out about it, so they can spend it all. You know, they do a generation.
Well, they have been. They've been spending mine however they want ever since 1949. So, I'll be 68 this year. They've had access to my monies and interest for quite a number of years.
Yeah, but once you call them on it, then they have to return everything because they shouldn't have spent it in the first place. But they do
true.
like it's kind of like a life insurance, but it skips a generation, so they don't have to pay taxes on it either.
Right. That's why the reason they don't pay the taxes is because they have your mother sign her maiden name as though she's not married. So that causes you to be born without a father. You never heard that one before, did you?
Yeah, I've heard that. I've been at this a little while.
Good. Good for you. I am so proud because few people know that's why they always have the mother sign her maiden name, not her married name.
Right.
So now the state can take control of the illegitimate child. See?
Yep.
That makes the child illegitimate.
At the bottom, she's converted from the mother into the informant.
That's correct. Very good. I'm very proud of you.
Yeah.
I have a great big Cheshire cat smile on my face. I am very, very proud of you. You have no idea.
I'm making it easy for you tonight, ain't I?
Yes, you are. Because so many people, they want to act like they've never heard this before,
Yeah. Yeah.
And like it just came out, and it's been this way all the time, and the more you try to wake people up, the more they want to stay complacent, or it's like they're in a rut. You can discharge any debt. They provided a way for you to do it, and it's out there on the internet in your face, and people don't even know it.
Yeah, they don't have that initiative. Most people have that line in the sand, where they just had enough and they hit the books and they go for it, whether it's a traffic issue or they take your kids away or their foreclosure or something like that, and they're under the gun and they want to figure it out right away, and that, lights a fire under them, gets them motivated. But these other people, I talk to people all the time that just have zero interest in it and they just want me to shut up, and I just, I'm just like, okay, well, whatever. And
well, just shut up. That's what I do. I'm not here to argue with people. I'm just here to share information. I have evidence of what I do. I'm not gonna give you my evidence, but I'm just letting you know that, if I trusted you, I would send you the unredacted documents.
Mm-hmm. Yeah.
So you can see.
What I like to do is, I'll go to a forum and I'll just throw up a thread and talk about stuff, and then I get like 100 people telling me to shut up and I'm crazy and I'm an idiot and I don't know what I'm talking about and all this stuff. And then one person out of 100 says, hey, that was pretty cool what you did back there. And I tell them, I've been at this for a while and there ain't no reason for me to talk except for that right there. There's one person that says that they like it or they got something out of it. For me, that's a win.
Exactly. That's all you need is one. And if that one tells somebody else, then it'll begin to, spread.
Yeah, and
I like the movie.
It keeps me going.
Yeah, for that. Remember that little boy in Pay It Forward? You want to help 3 people.
Right.
So if you just help those 3 people and those 3 people help 3 people, eventually everybody will have the information and it's your choice what you do with it. I'm not telling you to take the road that I took because it was very painful. It was very hurtful. Your own family members turn on you and start talking about you and think you operating 2 courts short of the 5 courts you need. You know what I'm saying?
Yep. All right. Truth, I'm going to get going. I think other people have a question, so I'm just going to mute out, and thank you for your time.
You're welcome, and thank you.
Okay. Bye-bye.
Good evening, Truth. Next in line, because Angela's having trouble with her microphone. Next in line will be Budman, and Angela's going to mute me back up. Budman, you're going to be unmuted. Go ahead.
Okay, I'm here. How may I help you?
Yes, hi, Truth. Let's see. You had said earlier, of course, the bank didn't make a loan. But you also referenced about us being the private, and I got a little confused. Does that? Well, how does that relate to the fact that they didn't loan us money in the private? Or was that just something different?
Okay. You need to restate that because they didn't loan you money. That's why you're asking by affidavit for a front and back copy of the loan check, which they can't provide you because they never gave you one. Let me put it to you this way. There's only one entity in the United States licensed to make money, and that is who?
Corporations?
It's the Federal Reserve Bank. Banks can't loan money. They don't have money. They would have to get it from the Federal Reserve. So if you did owe money, you would owe money to the creator of the money, which is the Federal Reserve Bank. You wouldn't owe it to a subsidiary bank or, you understand what I'm saying?
Yes, absolutely.
Because the property would be that of the Federal Reserve, not of the bank. The bank would be a fiduciary. It's like when you open up a bank account, they're your fiduciary. Well, no one taught us how to make that account private. Again, they're holding your assets. That signature card, that's an asset of yours. They're holding your property, and you didn't write on it that it should have been private. No one told us that we could. No one told us that we had that option. So now when someone wants to get into your account, say like our friendly I, R, and the S, if it's a private account, they can't access it. But if you're public, you don't know how to declare your status and make yourself a private people instead of being a public enemy person.
Yes, and now, of course,
correct. Go ahead.
You can't borrow money as a private person, correct?
You don't have to. They owe you. Did you not hear the previous conversation? They are making money on your trust account. They're managing your trust. Say, for instance, your birth certificate bond is a savings certificate bond that you were supposed to collect on when you got 18, but nobody ever told you. So now the interest on that bond is constantly accruing because no one came forward and said, I'm alive, I'm not dead, I want a full accounting of the investment that you did with that bond. And I want all the rights, title, and interest returned to me. That's the way I want you to think about it. See, everybody thinks that the federal government is your enemy when it's not the feds that's your enemy. Guess who your enemy is? It's the state. Who controls the court? The state. Who does the judge work for? The state. Who does the DA work for? The political subdivision of the state, because the DA works for the county. Just FYI. So, and the state gets what? Federal funding. So the state is being funded from your trust money, from that birth certificate bond, from that Social Security trust bond. So who's railroading you in court? Who runs the state? The Bar Association. Hello?
When you said that, all of your, like with the account where they pay for your needs, do you know anybody that's actually, that's being done for, or is that theoretical?
No, that's how trust operates. You're the beneficiary. And if you know anything about trust law, the beneficiary gives orders to the trustee. And the beneficiary tells the trustee, I want this car. I want this house. Make it happen. Anything for your life's enjoyment and maintenance, that's how trust operates.
Do you know of anybody that's actually been able to pull it off?
I'm not at liberty to disclose that.
With this, the revocation of the power of attorney, is that going to be included in a loan document when you borrow money with a mortgage?
No, it's the revocation is not. The limited power of attorney is. That's what. Yeah, there's a limited power of attorney. If you've ever been to a closing, you know they rush you through signing and initialing the closing docs because they don't want you to read them. Well, you have a right to get a lawyer's package so you could take it and read it for yourself, plus you can have an attorney read it. But now remember, they're in cahoots with each other, collaboration. They're conspiring against you. And as far as the attorney knows, everything is correct. But when you never get the loan check, then you should ask the attorney. Now what happens? They never gave me the loan check. It's a void contract. If you and I make you an offer and you accept it, and the consideration is for me to do something and I don't do it, it's a void contract. It's not enforceable.
Yeah, so they're going to say that they gave the loan check to the seller, but the reality is there was no loan, and that's the caveat, right?
Of course, they didn't give the loan check. Wait a minute, hold up, back up. When you fill out an application for a loan and you are approved, the next thing the bank does is cut the check to you. You would have to endorse the check for them to do that. They never did that. Your promissory note was monetized. That's what paid the title company and the seller. And they're going about their business. Now here comes the bank asking you, are you going to accept the debt to repay this loan that I never gave you? And because you don't do the 3-day right of rescission, you accepted a debt that you don't owe. I know you heard this. Go ahead.
Well, you said revocation of power of attorney and then a rescission of something else. Was that correct? What was the rescission of?
The same thing. I do. My revocation of power of attorney says I rescind, I revoke. You know, a rescission is when you rescind something. The revocation is when you revoke something. So I do a signature rescission, revocation of all initials, signatures, and marks. Even if my pen accidentally put an ink spot on the paper, I'm revoking all of that.
Okay.
So you want to make it crystal clear that they understand your intent and purpose. That's how trusts are formed. As long as they know what the truster's intent and the purpose of the trust is, you don't need a trust indenture to have a trust. You need intent and purpose of the trustor. And what's the intent and purpose of the revocation is to remove your signature nunc pro tunc. That means all the way back to conception, the 9 months before your earth arrival date. That's the type of revocation I do.
Thank you so much, Budman. At this time, Andrew would like us to move on. Southern Bell, number 1, you are being unmuted.
Greetings, can you hear me?
Southern Bell, go ahead. Going once,
Hello? Hello?
Greetings. How may I help you?
Okay. My question was similar to what the fellow had asked earlier was, or did you have knowledge of anyone who has been able to access their trust? Using the methods that you have, I guess you answered that because you didn't want to disclose that. The other statement I want to make is that whenever someone is making a mortgage or getting a mortgage and they're going to the originator or correspondent lender, those people don't know what's happening at a loan closing either. It's just with the knowledge of going back and reading how money is created with the modern money mechanics. And then, like you mentioned earlier, the Trvth in Lending that has all the information of what transpired at the closing, like how much went for appraisal, title work, and whatever, is something that, is paid out to third-party vendors, so to speak, and the loan originators don't have any idea this is what's happening. So it's only the higher-up people in the banking that have that knowledge.
Right, but you have to use the word alleged loan originators because now remember they're collecting your assets.
Right.
Everything that you sign is an asset of yours.
Right.
And when you fill out the application and you're approved, it creates a credit asset, which is a bank account that the average person is not cognizant of. They don't even know it exists.
Right.
But they know about the note.
So
there was so much money, and the fact that they transfer you from the borrower to a lessor or a tenant.
Mm-hmm.
Those are called clogging provisions. And that's a violation of your due process, and it's a violation of your right of redemption.
Okay,
and those,
I didn't understand. I'm sorry, I didn't understand. I couldn't hear. You said that's a violation of what?
Your due process. It's called the fundamental civilian due process.
Okay.
Which is a priceless God-given right, and your right of redemption, the right to redeem your property.
Right.
That's priceless. So whatever collateral that they may have, whatever liability insurance they may have, those rights supersede any monetary amount. So you can just wipe them out.
So what would you suggest, Trvth, that someone start that doesn't have this knowledge? What would be some of the best things for them to start researching or whatever to become more knowledgeable with this? And do you have a website?
No, I don't advertise. I'm a very private person.
Sure.
The only way you can contact me is through email. Unless you're a client, you can't get my phone number.
Mm-hmm.
But what I will do, I'll provide as much information. I will inundate you with information to read if you choose to read it.
Sure. Okay.
You're saying, sure. Let me explain to you. One book has 1,200 pages, just one book.
Right.
The next book has about 800 pages. So if you're serious that you want to do that, I'll send it to you. No problem. I'm just asking, would you please give a donation to Angela for me of $50?
Okay. And then Angela will put me in contact with you?
Yes. My email is at the bottom. If you go to my private audio under guest speakers, my email should be posted there.
Okay. I'm just not online right now. I'm just on the phone. I live way out in the country, so I don't have Internet access all the time.
Well, I don't have Internet, and I'm in the country, and I've been using my phone, but I can't send the attachments because the attachments are on my computer.
Right.
But I can communicate with you, through my phone,
sure.
email to email. I just can't do the attachments.
Right.
And it's a lot of material, and it's going to take you about the better part of 6 months to go through it.
You mentioned earlier about a February 2017 call and something about Christian Walters. What I know that he did a lot of information on trust. Is there any particular, I know that since he's passed away, but is there any particular one of his calls that would be most beneficial?
No, I have a document that I provided Angela. She posted it for her callers, and you could download it. It should be under my name as well.
Okay, on the website?
My private audio,
okay.
yeah.
That sounds great. Okay, thank you, Trvth, and I'll let somebody else come in.
All right, you're welcome.
Thank you so much, Southern Belle. Next in line is Southeast Texas. You're being unmuted.
Hey, Trvth.
Greetings. How are you?
Greetings to you. What's up, Doc? Yeah, I'm all right. We was talking before you got the recording going, remember?
Yes.
Okay. The constable that brought these 3 papers out, I told him I didn't want him. I didn't want them. They did not have my consent to even be here, and that I paid for this place 12 years ago. Should I keep those papers or return them?
You always return them. Special deposit, trust read. Make it property of the trust.
Okay. In other words, this is a false claim in an administrative court, more than likely, right?
Of course it is.
Okay.
But now,
go ahead.
This is your, make sure you get people's names because they have bonds.
Yep. I got it on recording. Everything I asked him, I asked him if he was a man or is he acting as a public servant, and he wouldn't answer me. Matter of fact, he wouldn't want to answer any of my questions.
It doesn't matter. If he came out there with a uniform on, he's doing business as a deputy or a police officer. So he couldn't be a man while he's at work.
So that should be returned to the court within what time limits, do you think? They got 20 days. Huh?
Is there a case number on there?
Say again?
Does the paperwork have a case number?
It has a number at the top. I really hadn't looked at it. It's legalese, false claim. But, yeah, it has a number on it, yeah.
Okay. You have my email, correct?
Right.
Scan it and send it to me. Let me look at it because you can claim that case number. How about that?
I can send a picture of it.
That's fine.
Okay. Now, what did you just say?
I'm gonna share with you how to claim the case, how to claim your docket number.
Okay. But return the process, right, with the claim?
Exactly. But it's something I want you to write on the docket. I want you to, the paperwork, special deposit, trust.
I got 20 days. It has to be within 20 days, or does it have to be returned within 3 days or 10 days or what?
No, you can return it anytime before the 20 days.
Okay.
And let me share this with you. If you fax it, it's considered same-day service.
Okay. I can fax it. Would probably be better than sending it certified mail, right?
I do both.
Okay.
Because I don't want them to say that the fax machine was out of paper.
Should I keep the original?
Yes, you do. You only give copies. You
only
keep
give
the
them
original.
copies back. Keep my original.
That's correct.
I was going to make sure that I didn't send them back the original, but I thought that's what I was going to do. But now I know better. I knew better, but it's been a while. See, after 12 years, see that that birth. Me and you were born in the same year, by the way.
Congratulations, we're 49ers. Hey, hey, hey.
Yeah, we're 49ers. Yeah. But around 95, 96, me and a friend have known each other since about 1985 or a little bit before. And I got him started like in the transportation code. And then we went through a lot of other things, and we'd come up with this birth certificate. Something's wrong with his birth certificate, Social Security number, Well, he got an original birth certificate and started looking all the words up on there. He's a ex-military guy, and he knew the military code really, really well. And I said, man, if you knew the military code that well, there's no telling what you can do. Well, man, he's burning it up. Of course, the father put me and him together. And he says, this birth certificate, like the man you were talking to before, he said, look, the mother is an informant on the man that impregnated her. We're all illegitimates. I said, wow, man, that went right in my brain. But everybody else, like you were talking about, they thought you were crazy. You know, your family members, your friends, you know, oh, man, I don't even want to know. You're too far out for me. But me and him and several others just took this up to a certain level. And then I've still been listening to the calls and doing this and that. But for 12 years, no one's made a claim that I owed any debt here. No one's even come and said, hey, what are you doing here? You know, I don't know what happened. What do you think happened with the 12 years? They were securitizing?
No, they couldn't. They had nothing to securitize because you only pay for their services. If the property is not registered, then what are you paying for?
Right.
There's no service being rendered, so no money is flowed.
I didn't register our agreement when I bought it from this woman, when I paid her what she required. So my next question would be, should I record a notice or something that I, a man, have paid this woman what she required as of now for then, back 12 years ago?
No, that's none of their business. Remember,
okay.
Private things have to remain private. Once you put a notice is public.
That's what I thought. I was tempted to record a notice that I had done this, but I wanted to keep it in the private. So the basic thing is just to return a copy of the process. Any other questions, like I said, well, who's the trustee over my property? I mean, you know, is there a trustee over my property?
There's a trustee over you. That's the president. His name is Donald Trump.
Oh, okay. So he's the trustee.
He's the alien custodian. That's why I say trust law is so powerful. You really need to investigate. You have to terminate your guardianship with the alien custodian.
Well, I quit using the name, the birth name, on the birth certificate, and do everything that I call myself in lowercase, you know. But they come out with the birth certificate name. I said, they called and said, hey, are you, hey, Mr. So-and-so. I said, there ain't no Mr. here. Mr. So-and-so here, you know. He said, yeah, I figured I'd hear that from you. I said, you? Who you calling you? Who you calling you? You know.
Okay, so let somebody else come in now.
Okay.
I'm looking forward to your email.
I'll get in touch with you, man. Thanks. Appreciate it, Trvth. Love you, man.
Okay, love you too.
Trvth, there is no one that have their hand up presently. But I had a question, if it's okay. I'd like to know if your system, in any way, if it intersects with something that I've been hearing about law and agency. Does it in any way?
It doesn't intersect, but you have to remember you are an agent for the all caps name. Now, the reason being, let me explain it to you this way. On your application for a name, the last name was always known. Then your gender. Then your first and middle name, if you have a middle name. But you were, for instance, your last name is Johnson. You were Johnson, Boyd, and then we're going to give you a name of Robert James. How about that? So you're Johnson, Boyd, Robert James. Now, they took that name and turned it around and capitalized it. But on the application, your last name always came first. Always. Am I right about it? I'm just asking.
Well, yes, absolutely.
So, because you write your name the way they taught you to write it, instead of the way you were named, you need to correct that. Sign your last name first, comma, first, hyphen, middle, or either last name, comma, first, middle, initial, but never first, middle, last. Because you're the agent for the all caps name. Stop forging that signature.
Okay.
You see how they get you to be complicit with their fraud?
I see it. And tell me,
have you ever? Go ahead.
Go ahead. No, go ahead. I interrupted. I'm sorry.
No, I can hold my thought. Go right ahead.
I thought that you were done. I was gonna ask you about bonds, if that fits into your system in any way.
You mean me writing a bond?
Yes. Do you write bonds, personal bonds, or those go bonds?
No, it's not necessary. There's bonds out there for you to use that discharges debt. So it's not necessary for me to write a bond.
Okay.
See, remember I said earlier, there's more than one way to skin a cat, and the information's out there, and, people want something for nothing. Go on the Internet. The information's on YouTube. You can find out the same thing I found out, except I do a little bit more extensive research. I know how to use the same bond to discharge a mortgage, discharge credit card, car note, student loan, hospital bill, IRS debt. That's what I didn't remember. So there's a way already been provided for you. But what I was going to say before you asked, when we had the talking at the same time, have anybody ever told you, they held their thumb up, like the okay when you hold your thumb up and say, stick up a finger. And then when you hold your thumb up, like their thumb is up, they say, I asked you to stick up a finger. This is a thumb. It is not a finger. But because you see me with my thumb up, and I got thumbs up, and I say stick up a finger, and you give me a thumbs up in return, you're not listening, you're watching. And that's how they make us complicit. So if I say stick up a finger, I mean any of the other four, not your thumb, because your thumb is not a finger. It would be called a finger, but they named it a thumb, so it's not a finger. You got that?
Yes.
That just makes us complicit to their fraud.
So basically, you're saying that they're using our other senses to somewhat manipulate our thinking.
Exactly. Because how many times have you been taught, do not judge a book by its cover? But we do it all the time. When you read the title page, the author, and you're looking at the cover, you are judging the contents of the book. But that's a programming that they have. It's a psychological, reverse psychology, whatever you want to call it. They're teaching you to do what they're telling you not to do. So I'm going to tell you, don't judge a book by its cover. Then I'll give you the book. When you look at the cover, what's the first thing you're going to do? Judge the book. Because the power of suggestion, the power of words. I've already planted it in your head previously. Don't judge the book by the cover. Now I'm going to give you the book. That's what you're going to do, judge the book by the cover. How can you not? So if I want you to do something, I'm gonna suggest it to you.
Can you give us some examples the way our government, where they're actually utilizing what you're saying, just for those that are listening?
Okay, that's how the government is ran. That's where the funds come from. There's enough people that avoid paying taxes. The people's taxes is not what's running our government, paying our Congress and senators billion-dollar salaries. That's coming from our trust account that nobody's made a claim to. Again, the Cesar KB Trust Act of 1666 says that you're dead and lost at sea, and until you come back and say, I'm the beneficiary, they're going to continue to administer your estate or your trust. From president to president to president. That's how it's been done all the time. Ever since they created, this is fraud at its finest. This is fraud at its finest. It's a magnificent piece of work. And you have to appreciate it, that, you really have to study to get uninvolved and unentangled in their web of deceit, lies, and cover-ups. Rod Class has an excellent YouTube. Attorneys are not even lawfully able to operate in a courtroom. There's no congressional law, no legislative authority that allows an attorney to even walk into a courtroom and operate as an attorney. And he gives all the laws, the case law you need to support that. But you have to do your own due diligence. I did my due diligence. I looked up. When somebody tells me a law, I write it down. I Google it. I pull it up. I download the PDF. I take my time and read it and dissect it.
Awesome. There's a question.
Go ahead.
I'm sorry that I thought you were done again. There's a question in the chat. Voice of Reason asks, what is the state? Can anyone describe the state? Is the state real? Can it be proven to exist factually? I'm sorry.
Okay, but there's many states. There's a state, like he's talking about, that's a part of the country. There's the state of confusion. What state is he referencing? There are many states. Some of them have to do with mine. I would say they all have to do with mine, because the boundaries of a state, like when the police officer asks you, are you a resident of this state? Ask them, what is this state? He can't give you the geographical boundaries of the state because he doesn't know. So what state? And who established those boundaries? So what state? It's a state of confusion.
What she, voice of reason asked, I guess they're trying to clarify. My question is, can you factually prove the existence of a state? I don't know if that clarifies anything for you.
Yes, you can. Because, number one, people can do stuff how? By affidavit. And the unrebutted affidavit stands as truth in commerce if it hasn't been rebutted in 30 days. And that's a fact, and it's called a material fact. And yes, you can. Because it takes another man to rebut a man's affidavit. Anything you do, as long as you do it by affidavit, it takes another flesh and blood person, people. Excuse me. It takes another flesh and blood people to rebut that. A corporation cannot.
So they're continuing. So you claim a state is a body politic? That's what voice of reason continues.
If you're referencing like the state of Michigan, yes, it's a body politic. Have you ever written down the city without the state? Have you ever written down the county without the state? Usually it's always the city and the state, the county and the state. Or certain real estate documents when I was coming up, it was always the city, county, and the state. So they were all inclusive. I'm from Wayne County. So it would say Detroit, Wayne County, Michigan. Okay? They're all political subdivisions of the same body politic, which is the state of Michigan.
What makes up a body politic? Voice of reason asks.
He needs to go, the voice of reason needs to go to his state and find out when they became a state, when they came up with their constitution and when they joined the union. And it sounds like, what was the gentleman's name 2 weeks ago? Sounds like voice of reason knows Donaldson. Because he is so off topic about what we're talking about. My topic was mortgage and truth in lending, so why are we talking about state and state of mind and stuff like that? It has nothing to do with the subject matter that I chose to address.
You say he knows Donaldson.
I'm pretty sure. That's just like I know truth very well. You know how well I know truth, right?
Yes, yes. I heard you speak with him several times. What they're saying is, I guess, what they're saying is, I'm trying to show you that there is no state. It is an illusion, is what their comment. Voice of reason.
Everything is an illusion, and if you don't acknowledge it, why is red red? Because we all agree to it that it's red. Isn't that an acknowledgement? In a democratic society, what? The majority rules. So again, why are we on this topic? He's one person. The majority says it's a state. He's one person. The majority rules. He's a minority. They're not going to pay him any attention. Or her. Forgive me, I'm not trying to be biased. So why do people do what they do to you? It's because we allow it. And one of the first things I used to teach when I was teaching law, because I used to have classes every week, was Lambert versus the state of California. Because the judge is always saying, ignorance of the law is no excuse. Well, Lambert versus the state of California is the court case with that.
Hello.
Hi, Angela.
Oh, my God, you could hear me?
I certainly can.
Oh, my God. I didn't mean to interrupt. I've been fiddling with this thing the whole time. I'm not going to move anything, though, right now because it's working. That's great. Wonderful. But go ahead. I've been listening right along. And thank you so much, Sal, for taking over. Oh, gosh. It's been so frustrating. But I didn't mean to interrupt. Go ahead.
That's not a problem. Everything happens for a reason. And what I'm saying is they took away our privacy without our knowledge and consent. And we went along like sheeple because that's what they were programming and training us to do for generation after generation after generation. Now somebody has picked up the Trading with the Enemy Act and the Emergency Bank Relief Act of 1933 and realized that it's not applicable to us. So again, you have to use the eraser on a pencil and go back and correct the mistake. Don't assume I'm a public citizen, which I'm not. You could fill out a driver's license application and put on there that it's private. You'd be surprised what that'll get for you. Start putting private down the right margin of your document. That is special, private, and priority. Start restricting your signature by colon. If you're going to sign first name, then last name. Put by, and then put agent after that because you're the agent for that name.
That's true. You know, Connecticut has their hand up. You want to take another question?
Sure.
Okay, Connecticut, you've been unmuted. Go ahead.
Hi.
Hi.
I was just wondering, how do you utilize an unrebutted affidavit?
You file it on a UCC-1 and use it as an exhibit.
Oh, okay.
So now you can bring it into court.
Okay, and when you go into court, do you file it in the case and then you try to bring it up? Because pretty much I've had an unrebutted affidavit, but it's been pretty much ignored, but I didn't file it on a UCC-1. Okay,
but you have to have an affidavit. It's just like, let me explain it to you like this. You know a QWR, which is a qualified written request?
Right.
Okay. When they don't answer it, you have to do an affidavit of non-compliance to clearly written and established federal law. You understand that?
I'm following slightly.
Okay. So what I'm saying is, if the affidavit hasn't been rebutted, you have to have a document that this is an unrebutted affidavit, and you have to state the dates and times to show that it is an unrebutted affidavit by affidavit. That's what I'm saying.
I got you.
So where's the corroborating document?
Well, it was an affidavit just to state what happened, but then after that, I didn't write anything to say, okay, this affidavit was unrebutted. You know, I didn't do that.
Right. And the unrebutted affidavit helps make a prima facie case when you're on the public side, because that's what I was sharing when I used to teach and I first got started. I was always on the public side battling. But
Right.
the better side for us to be on is the private side. So when you learn better, you do better. And when I started understanding trust and that we're private people and we're too busy trying to straddle the fence, you know, we're trying to be a private people and a public citizen, and you can't commingle.
Right.
That's when you go to jail, when you commingle.
Oh.
Well, if you go into court for any reason and you tell them that I'm a flesh and blood person and my rights cannot be seen by this court, my rights can only be seen in the private because they're trespassing on a private trust, you claim that court case with special deposit and return it as trust res, you own them. You
Okay.
own everything.
Okay.
But you're not the name, you're the agent for the name. And only use your first name to keep it simple so you won't get confused. When they say your full name, that's the all caps name. When you're being an agent, just use your first name so you'll remember the different positions. In the event you're not accustomed to signing your last name first. So just use the first name. No surname.
Oh, okay. Because I've gone into court and I've said that I'm the agent, and what he wound up doing, because I've gone back and forth, I think the last thing he did was kind of say, well, you're not here, because I wouldn't say the name. I would say that I am, the executrix, or I am here for that matter, or, I didn't say the name, though. So he said, well, you're not here. You can't.
Why didn't you bring the name to court? Because they're talking about the birth certificate. When you say it is in the courtroom. Did you hear what I said? It is in the courtroom. All you have to do is produce the birth certificate because that's who they're prosecuting, not you.
Right. Okay. So then I just bring the name to court and say it is here.
Right. And your birth certificate can't talk, so you have to be the agent. Am I correct?
Right. Right.
Okay.
Yeah, because I said that's what I was saying. I'm the agent. I forgot the speech, but I had the speech prepared, and that's what I kept sticking to, that I'm the agent. But now I'll just bring the birth certificate, and that's that. Now the other thing I was trying to do was send documents to the clerk of the court, and what he's been doing, or she, whoever the clerk of the court is, they've been just mailing it back and haven't been accepting it. So I'm trying to figure out.
And what have you done when they send it back? What do you do?
Mail it back and have a cover letter with it,
Very good. That's what you're supposed to do. When they send you stuff back, take it out of the envelope, put it in another envelope, and send it back. Now, how many people do you think know that?
But we've been just going back and forth, so I don't know how to take it. And I've been mailing it to them to stop the process, but they'll pause, but they haven't been stopping.
And you need the declaratory and injunctive release to stop the process.
Oh.
And you also need to make the attorney, because he's doing an invasion of privacy and identity theft using your name without your written consent, you should make them the trustee.
Yeah, I did do that. It's just that I've been doing stuff but don't know how to take it to the next step. But he is I did make them the trustee. I did appoint them trustee. Okay,
so did they just claim the trust? Did they say they're not going to be the trustee?
No, they did not.
They did not respond to it?
Not at all. And I defaulted them. But like I said, I don't know how to take it to the next step.
If you defaulted them and you did it properly, then you take it to the clerk of the court and get them to sign off on it. The clerk of the court signs the default judgment, providing your mailing process is correct. If you did the administrative process, you gave them a notice of fault, an opportunity to cure before the default, the clerk of the court will sign off on it.
Okay, so I just go into the court and ask for the clerk of the court and then tell them I need you to sign off on this?
No, I didn't say that. I said, did you send a notice of fault and opportunity to cure before you defaulted them?
Yes.
Okay, you never said that. Now you take it to the clerk of the court. If you followed the administrative process and it's complete, the clerk of the court will sign that it's the default and stamp it.
Okay. All right. So, and now something like that, I would just have to go to them and speak to them about it, or I can mail it, or.
No, that you take you that's personal. You have to hand deliver that, and you have to make sure you're talking to the court administrator and not a desk troll. You know what I'm saying? Okay.
Yes. Okay. All right. Thank you so much.
You're welcome.
Well, that's it as far as questions go right now. Can you hear me?
Okay. Yeah, I hear you fine.
Okay. I have to keep checking. Thank God. Well, I pulled it in and out of the socket like 3 times. I guess the third time was a charm.
So I was gonna send you some paperwork, but like I said, it's been thunderstorms and stuff. My internet is down, and it's stuck sending an email that I was trying to send to someone, and it never went through. So trust me, we've both been having problems today. But I always like to send you paperwork, especially about what I'm going to talk about, so you can
and I'll
follow
post it. I'll post it up on the page we have for you. If you want to go to that page, it's myprivateaudio.com.
MyPrivateAudio.com. I already know that. But
and then click on the guest speakers page, that link at the top, and then you click on Trvth's name, and that'll bring up her page, and it'll show, whatever she sent me to post.
So I know you heard that anybody that wants any document from me, I asked them to send you a $50 donation, and this is unsolicited by Angela. This is my doing, and I'm asking you to, if you want something, stop wanting something for nothing, because people pay the price to get the information. The information didn't come to me free. It took me time, took me money. It took me people training me, people calling me stupid and dumb because I didn't get it, And I took a lot of abuse because my teachers were chauvinistic. And honestly, I was just too naive to even realize it. But every time I went to class, they were saying, she's so dumb. And I was the top person in my class.
Wow.
But they, like I said, I was too naive to even realize my teacher was a chauvinist.
You've got some. I was going to say there's 3 people with their hand up if you want to take some more questions, but go ahead.
Sure.
You want to?
Greetings. Sure.
Well, first of all, let me ask you this. Do you want to talk to Donaldson? He's on. He has his. We have 2 others. You want them first?
Yes.
Okay, Budman. Go ahead. You've been unmuted. And then we have Delaware, which I believe is Dave. But go ahead, Budman.
Yes, thank you. I just wanted to clarify, when you're saying giving the default to the clerk, do you actually file a motion for default judgment, correct? Right?
No, that is not correct. You can get a default from the clerk, and then you do a motion for default judgment to have the judge sign off on it.
Okay, so
two separate processes.
So so explain that process a little bit better. So you just take the default to the clerk and you ask for a default from her, a signed default?
Or him, correct. Now, what state are you in? You need to find out what that, look, I'm from Michigan. I'm the type of person I'm hands-on. I used to have a badge that I can go through the same side the lawyers go through. I can bring a gun into the court, the whole 9 yards. I'm not saying you gutsy like I am, but you have to go meet these people, establish a rapport with them to find out the information you need. Anything I want in the state of Michigan, I could walk in there. They know my name. They know who I am when I walk in there. And more than likely, I have a candy bar for them. Well, I had this one clerk. She liked Twix. I used to go to the wholesale place and bring her a whole box of Twix. Every time I stepped on the 5th floor of the county building, she'd say, right after this customer, come to my window. And people just be looking at me because I haven't pulled a ticket. I don't have a number. You need to establish a rapport with the people you're going to be doing business with. Ask questions. Tell them you're a student. At the time, I was a student. And they refused to take me to the law library with them. They only took the guys. And like I said, I was too naive to realize that they were chauvinistic. I have to go to the law library all by myself and study. I have to pull the cases up myself and print them out. There was nobody there to guide me, so I made friends with the librarian. Who knows the library better than the librarian?
Well, now, this would actually be a summary judgment, right, not a default, because default's when they don't respond. Summary is when the evidence is on your side, right?
That's correct.
Now, and you're saying that but with that evidence, you should be able to get the clerk to sign off on you give her something to sign, or she would. Check in my state, but in your state, how does it work?
You have to bring the entire package. She has to see the mailings that you did, the dates between the mailings. She's not going to just, or he's not going to just sign off on it and stamp it unless you have a proof of service, the date that it was mailed out, the date the second one was mailed out, the time that's between, proof of service, and the default, when it was mailed out, proof of service. So you should have 3 proofs of services. The time should be X amount of days, however much time you're giving them. You know, that's the entire process. She or he has to see the complete package, what you did. They're not interested in the content. They're interested in the mailing.
Right, but then what do they issue, or what do they do next?
They'll stamp it and put the court seal on it to grant your default.
Oh, okay. Then you take a motion before the judge with that information.
That's correct. And then you do a motion for a default judgment.
Anyway, thank you, Angela.
Next.
Can you hear me?
Yeah.
Can you hear me?
Oh. And now.
Oh, okay. Next up is Delaware. Go ahead, Delaware. You've been unmuted. Is that you, Dave?
Yes. An earlier caller asked if you had any validation or verification that bills had actually been discharged using this. And I don't think the process is the same, but I can personally witness that I was able to discharge all of the hospital bills and therapy bills and doctor bills and ambulance bills and all those bills with a assignment of partial interest up to the amount of their claim based on a recorded security agreement indemnity bond financing statement created by Howard Griswold. So anyone who would like to duplicate that, send $10 to cover the postage and copy costs to peoples-rights.com Association, or People's Rights Association, care of 1624 Savannah, Savannah Road in Lewes, Lewes, Delaware, Delaware. Please do not send it to a non-existent fiction place titled DE or numbered 12345 or some other zip code numbers, because we do not live inside the post office building, which has a zip code number. We're not in the post office building, and we do not get a discount on our postage, so we do not use the postal zip code number. However, if you are one of those bull-headed patriot people that use one anyway, please put it in brackets or parentheses, 19958. Anyway, as soon as we get the donation to cover the reimbursement costs, we will send the 48-page data package to you with the questionnaire blanks, and you fill in the blanks and mail them directly to Howard Griswold, and he will create the document, the security agreement, indemnity bond, financing statement document for you based upon the answers you have given him in the blanks. And he mails that document directly to you for you to follow his instructions and record the security agreement, indemnity bond, financing statement at the State Secretary of State, UCC office, following Howard's instructions, which include that when you get your copy back proving that you've actually done it, and Howard needs you to photocopy the front page only, because that's where the numbers that the state stamps on it appear. They're on the front page only, so Howard only needs the proof that you've followed his instructions, and send him back that front page only, and he then, based upon those numbers, he can create those documents for you. And he can then create the the assignment of partial interest, or if you just want to terminate the registration of some private property, such as a land deed that was stolen from you by being recorded, your private property deed was recorded in the public property records without you receiving any just compensation. The communist BAR British Accreditation Registry lawyers failed to give you the just compensation. So they've accomplished a taking of your private property without just compensation. But of course, you never asked for just compensation, so they never paid you. Anyway, if you want to terminate that, you enjoying the benefit of them holding your land in trust for you, based upon your security agreement, indemnity bond, financing statement, Howard can create a affidavit of commercial notice, which, following Howard's instructions, you serve that on the county tax assessment office, and possibly record it also in the public records, terminating the deed, and that effectively discontinues you enjoying the benefit, and they no longer can send you a tax bill or have your land, private property, subjected to their code regulations, such as you must keep the grass mowed to a certain height, or you must fix the gutters or paint the house, or whatever the rules and regulations they may have. None of it applies if the deed's no longer being held in their files, and that's terminated by that affidavit of commercial notice. Anyway,
Trvth,
as soon as we get the $10, we'll mail you the process.
Are you familiar with Howard Griswold's work?
Yes, I am. And the process we use, we have 3 documents. We have the cover letter, we have the statement that we're discharging, and the BC, which is the birth certificate. We use 3 documents, and 3 documents only, not a 48-page packet.
Okay. Do you want to talk to Donaldson?
Of course.
I think he's dying to get on here. He's like in the chat, I have a good one, a good question for you. So,
yeah, but
all right.
before you leave, if it works, I'm a firm believer. If it works, then work it. But that's on the public side. My whole conversation is about equity and how to become private and do things on the private side. And the reason you can do it is because you're asking for it to be sealed and ex parte, which means that it excludes the public and the press, which is why you're not allowed to talk about it. because you're asking for it to be sealed in ex parte, which excludes the press and the public. Okay? So don't think I have evidence of everything I'm saying, but I just can't share it with anybody because, you know, people put other people's information out there, and I don't like that. And I asked them politely to redact it. I have a document on a script, SCRIBD, that I didn't put there, but my name is on it, and I couldn't get them to take it down. They told me that I need to send them an affidavit. I said, well, did you verify the information or the person that posted it? Remember that guy out of Florida, what's his name, Bob Hurt, Angela? He posted some
Bob
information.
Hurt.
Yeah, he posted some information under my name without my knowledge and consent. So I'm just saying, I've already been bitten, and I have no desire to be bitten again. If you really want the information, you're gonna give a donation for it.
Okay, you ready for Donaldson?
Of course.
Okay, you've been unmuted. Go ahead, Donaldson. And again, thank you, Sal, for your help.
Oh,
hello.
Greetings. How are you?
Good. How you doing?
I'm doing great.
Hey, you said you had a good question.
I do, because it becomes with a little bit of a precursor, because I'm going to read the case law that leads me to my question. Like I have something from Massachusetts in 1926 here, talking about the name of a person is distinctive characterization in word or words and initials by which he is known or distinguished from others. Let's see some other case law here from 1911 in Illinois. Oh no, let's not do that one. Here's one. The name. This is Massachusetts, 1935. The name of a person is the distinctive characterization in words by which he is known and distinguished from others, and description is not the equivalent of a name. The one that stands out the most, though, is for me right here is this one from Kansas in 1916, where in Badger Lumber Company versus Collinson, 156P 724, they found that a man's name, in quotations there, is the designation by which he is distinctively known in a community. I find that to be pretty astonishing. But nowhere does it say that, it's anything separate from the actual man, or person, meaning legal person, like the man. The name is not a legal person. I want to know if you have the evidence to prove your claim that the name is a legal person separate from you. Thank you.
Okay. The name is an unincorporated corporation. Okay? So that is not how the application, again, was filled out. They turned it around. If you get a copy of your mother's application for your name, you'll see that the last name was first. Your gender was second, then your first and middle name. That's your evidence. They turned the name around and put your first name, middle name, and last name. That is not how you were named. You always had your surname before they knew if you were a boy or a girl. You had that last name. That's your evidence. But you're asking for case law? No, I don't have the case law for that. But I do have documentation from the hospital. I do have documentation from the state that they turned my name around. And where I'm from, we have a county birth certificate because your actual birth certificate is generated in the county and then the state takes over. Most hospitals in every state is county ran. So you should be able to, the birth certificate with the feet print and the fingerprints, that's a county birth certificate, not the state. Those are the evidences I have. Case law, no, I do not have it.
Okay. The reason why it's a kind of a two-part question. I appreciate you, Angela, keeping me here, because I'm going to bring up another document. I put both documents that I'm sharing with you guys into the chat room, so for anyone that wants to grab this information, it's right there. And this one is in an action against, and by the way, this is Donaldson, and I want to thank Trvth for taking my question. In an action against a corporation or an unincorporated association, the summons must also notify the person who is being served of the capacity in which he or she is served. Mind you, all of this is private and confidential. In particular,
it can't
the summons.
be if you're talking about a person, Donaldson.
Oh, I was talking about this conversation with us.
I beg your pardon?
I was talking about the conversation. What I'm saying to you right now is private. I'm just between us, on the call.
No, I thought you were saying that's in the documentation of the summons that is private and confidential. Because a business, remember now, all corporations are considered legal persons that can sue and be sued.
Well, hold on one second. You said all corporations are considered legal persons, right?
Right.
That doesn't mean that because I'm a legal person, I'm a corporation, though, does it?
Yes. The legal person is a corporation. But you're not a legal person. You're a flesh and blood, God-speaking spirit man.
Well, if you allow me the leverage, just a little bit of leverage here to finish reading this, and then you can respond to it, because I really want to get your response on this. It addresses the issue that you just mentioned about the corporation status. Here we go. In particular, the summons must state the name of the entity on behalf of which the person is being served, and the appropriate statutory provision that authorizes service on the entity. So they have to actually state the name of the entity, right? And if the service is also being made on a person as an individual, the notice must indicate the person is being served both individually and on behalf of the entity named in the summons. So I'm getting from that basically, if it doesn't say, John Johnson, for John Johnson Corporation, then there actually is a legal person that is separate from the name. What do you think? Thanks, Angela.
Okay. It sounds to me, because it's statutory, again, you are not the name. You are a flesh and blood, God-created, spirit-speaking man. There's no way that you could be a corporation because you're flesh and blood. Corporations don't feel. You feel. You have emotion. Corporations don't have emotion. Corporations do not suffer loss. Like if someone that we know and love happens to transcend. The fruit of the Spirit, it doesn't matter if you believe in Scripture or not, but the fruit of the Spirit, love, joy, peace, corporations cannot experience that. And it's very important that you know you are not an individual. You are not a person. You are a flesh and blood, spirit-speaking man, God created. That keeps you in the private. My copyright that I referenced earlier, it's a biometric copyright. And I copyright all the things that God put inside of us. That's our RNA, our DNA, all our bodily fluids, the epithelial cells. I put a copyright on everything. And all of that is inside the appellation or the name. And your name is how your mother chose for you to be addressed. And she addressed you by first name only. I doubt very seriously she called you your whole name when she was calling you. She always called you how? First name only. That denotes the living being. You're not an entity.
Well, let me ask you a question. Can a man because this Kansas case right here, it said from 1956. If you go and take a look at it, click it, open it up on the right-hand side, it actually says, you guys, a man's name is the designation by which he is distinctively known. Now, this, mind you, this comes from, I believe, a district court out there. Okay, so it's not a circuit court decision, which means it would basically be able to be used as with full faith and credit.
Okay, well, check this out. How about all these people that have nicknames? They are known by their nickname, which is not their name. That shoots a hole in that court case right there. Your name ain't Sonny. My name is not Sister. But if you said sister in my house, you were referencing me. I was the only girl, so I was the sister. And that's what I was called. I was never addressed by the name my mother chose for me to be addressed by. And it's an address. The appellation is how your mother chose for you to be addressed in life. What's your address? That's what's your name? What's your address? How did your mother choose for you to be addressed by other people in life? It's an address. And you have to use U.S. Supreme Court cases, basically, when you want to use them in other states. Yes, there's full faith and credit, but you're not from Kansas, so you can't exercise the full faith and credit of Kansas, and you're not that's not your state.
Well, I mean, it depends on my initial. I believe it depends on my initial plead. I want to say pleading, and I know you want to correct me, but withhold if you can. Bottom line is, if you, I just presented some evidence, right, that didn't come from, it didn't originate with me. I just went to the law library, saw the name and the words and phrases, and then it's case law. And I know that's kind of it's not a primary source. Well, actually, it's a primary source of law in this country. Case law is. Now, it may not be precedent, right? I know you can agree on that, but I mean, it's still something that you can use if there is no other provision or statute covering the issue. Then there's that case law, and it may work to sway the decision of whoever the decision maker is. We're not arguing, I don't want to argue with anyone on the call. Actually, I actually appreciate the amount of attention you guys give me. I really love what you're talking about right now. I mean, this got me thrilled. It's got my blood, circulating. I feel like my, adrenaline going here. I do feel excited about the topic of the name because I have seen case law that states that a name is merely a designation of a decedent. It's basically a tool to keep track of the assets of a decedent's estate. Okay, so the name really just is used to keep track of the debts and assets, right, of a legal person. And then at the time of death, the decedent, right, the estate has the name to basically, that's the name that has the attachments of the debts and the assets to it. And then who the administrator, they're going to figure out what to do with all of those things. Wouldn't you, I mean, from that perspective, wouldn't you be convinced that this argument that we are somehow not the legal person and that the name is faulty, to say the least?
Well, you're incorrect because the all-caps name represents the decedent. You need to look up the dead man's law for your state. They have a dead man's law. That's why they put all-caps names on tombstones in the graveyard to represent the decedent. The decedent is a live person. The all-caps name represents the flesh and blood human being if you don't know how to separate yourself. And we studied this years ago. You're just now coming into the knowledge of it, so you're not familiar with...
Wait, excuse me? I have to correct you right there. I've been studying law for quite a long time. And I came into the knowledge years ago. But I'm actually sharing.
You didn't allow me to correct you when you said something that you spoke for me. So don't do it to me. Offer me the same courtesy that you asked for. Because you misspoke something about me. And I've been studying law. I am 68 years old. How old are you? So however long you've been studying law, it's longer than you. I've been studying law longer than you've been alive. You feel me? So you're saying that to say what? Your knowledge is superior to mine. I am trying to correct you and let you know that we knew years ago that the all capital name represents a decedent who's walking around, living and breathing. The decedent doesn't necessarily mean after transition. You're considered a dead man. Again, the Statutes Act of 1666, until you come forward and terminate the guardianship of the alien custodian, you're considered dead and lost at sea. But once you come forward and terminate the guardianship and let them know you are alive, the administration of your trust in your estate ceases at such time. Did you hear that part of the conversation earlier today? I yield to you.
I muted him out.
Oh, well, please let him respond.
Okay, hold on 1 second. There you go.
Must have missed what you said. Yeah, I must have missed what you said regarding it. Can you brief me again?
Okay. See, now that's.
I don't mean to disrespect you. I apologize.
Okay, the decedent is not necessarily a dead person that's buried and dead. They consider the all caps name representative of a decedent. That's what the dead man laws are. Even though you're alive, because you have not terminated the guardianship, the Statutes Act of 1666 considers you dead and lost at sea until you come forward and terminate the guardianship and let them know that you're alive. And then the administration ceases over your trust.
Right. Actually, no, what you're, I hear what you're saying, but in common law, you're talking civil law. That's a civil process. Due process is a civil feature.
That is not civil law. See,
well, due process, right? You're talking due process. I'm sorry. I thought you were talking about the law.
Right, but see how you interrupt me, but you ask me not to interrupt you? I'll let you know when I finish, because I will let you know. I say I yield. That means it's time for you to speak. I'm yielding to you. Okay. Can we agree to do that?
Well, sure. I can agree to have that style of conversation with you. No problem. I yield.
Okay. Well, I appreciate it. Thank you so very much. So that's what I was trying to say, because the things that we learn, the box what you put the money in when you have a payment due and they want you to write the amount that you're sending in, it's called a tombstone. And if you haven't taken accounting, you would know that. But everything that they design, everything that they orchestrate is for a decedent that's alive, but they don't know who they are. And they're taking full advantage of that while they constantly perpetrate fraud on the living and breathing man and woman. I yield.
I accept. I appreciate you yielding the mic back to me, and I'm well aware of the Statutes Act, where the City of London was on fire and they had to take all of the property into the custody until the people would come back and all that. So I mean that's a fact of law in history. So no one's denying that. What I really like, I think, about what you said is that there is some relevance to the fact that until we step forward and say, yeah, by the way, I'm not dead. I'm actually alive. So you can't treat the name as if it's the name of a decedent. And you do that the same way that you're talking about doing, just through correct writing correctness or whatever, to the proper authorities. I yield.
Well, not only does the Certificate Act talk about the property that they got in England, it also declared every man and woman on earth dead. That's how that happened. That's how we all became living decedents. I yield.
Is that my responsibility to know about all of those laws and rules? Should I even consider law as applying to me? You know, all those acts of civil actions of Congress or of British ancestors or whatever. How in all this madness does that stuff apply to me when I'm just me? With no minimum contact, as they would put it. I yield back.
I'm sorry, did you yield?
Yes, I yielded back to you after I asked you how any of that stuff actually applied to me. I'm not trying to pull a Mark Stevens, but it's, after doing years of studies, you kind of figure out that they have to prove jurisdiction, and there's ways that we actually assent to the presumption of personal jurisdiction.
But again, you're talking public and equity is private. And you can't commingle.
Okay, did you yield just now? Or?
Yeah, I'm yielding.
Okay. The reason you brought up, you said it's public. So when you said that, I thought about the mother statement that you made earlier. We were talking about the mother listed on the birth certificate with the maiden name. And I was listening. I do listen to you, Trvth. You're listened to. That must feel good. The interesting thing about that is that it's in civil law countries, right, that they, from what I read, that they actually apply the last name of the mother to the newborn or to the child. And so if you're saying they don't put the actual the father's name and they put the mother's name, what they're doing is they're proving that they are operating under that the birth certificate itself is a civil feature of the civil law, separate from common law. So it doesn't apply to you or me. It's for them. I believe that, don't you believe, and I yield after this, that the birth certificate serves a function merely for the government and not for you or me?
Did you yield? I'm sorry.
Yeah, I do yield, and that's going to be it for my questions. I appreciate you taking all my hammering here, because I really have, I'm asking you these questions because I've seen these writings that deliver the information. So I yield to you. And the last question was, yeah, go ahead.
I heard the question, and no, that's not accurate. But, how can two people agree to walk together? How can two people walk together except they agree? So you disagree with my findings. And like I said, this is something we studied years ago. You've heard of merchant law. As long as you're handling Federal Reserve notes, they consider you to be knowledgeable in banking, which you're not. So you ask, how are you supposed to know these laws? Because any civilized society is governed by laws. You have to know the rules of the community. You don't have to know their civil law, but God's law. That's what makes you, for lack of a better word, that's what makes you sovereign. And I don't particularly like the word sovereign citizen because they put such negative connotations along with it, but you are a sovereign citizen. But because they want to rate you as a terrorist if you use that word, it makes us apprehensive to use it. But I know that, the court cases, like you like to quote court cases, look up Chisholm versus Georgia or Yickwood versus Hopkins. Both of those cases say that people are sovereign citizens without subjects. But I'm not trying to press that I'm a sovereign. I'm trying to press that I'm a flesh and blood living being, God spirit speaking woman. I'm not trying to press that I'm the legal fiction. I'm not a deceiver. Right. I'm alive and well. So I did a termination. Are you interrupting me, really?
No, I'm actually concurring. I do that. It's a conversation, so when I'm letting you, it's called feedback. I'm not interrupting. Go ahead.
But you are.
Well, it's called feedback. It's a conversation style. I apologize if you feel like that, though. Yeah.
No, but you are, because you stopped. You interrupted my train of thought.
Well, you.
How can you say that you're not interrupting when you interrupt my train of thought?
I muted him out. Can you hear me?
Okay. Yeah, I'm fine.
All right, we have
good.
a couple more, and there are two more people with their hands up if you want to continue.
Sure. Let's take them.
And then we'll call it a night because we're over the 2-hour mark already. Surprisingly.
All right. Fine.
Okay, great. Gazoo, go ahead. You've been unmuted.
Hello again.
Greetings.
Truth. Man, this is pretty cool because I'm sitting here thinking about the stuff that you were saying when we were talking earlier, and I'm listening to you answer the questions, and I'm thinking, and I just made some connections here, and I just want to share with the group. It may clarify for some people that, okay, the public side is the dead side, and the private side is the living. So that's why you want to go into equity, so you can. That's like proven life, because you have a conflict if you try to commingle and handle it on the public side using the private. You know what I mean? Does that make sense?
Exactly. That's exactly how you go into equity. You go into court and let them know there's a conflict between law and equity. Those are the exact words you would use. There's a conflict here between law and equity. And anytime there's a conflict between law and equity prevails. They have to go to the private side. And I have supporting case law. So that's exactly, you're exactly right. There's a conflict. You're not allowed to commingle the public and the private. I don't know of how many of you are familiar with James McBride. He wrote an instrument for $7 trillion that Treasury negotiated for him, and they notified him that they negotiated the instrument. They asked him, where do you want us to put the money? He gave them the instructions, what account he wanted that money put in. They deposited the money in that account, called him, said the money's in the account, you got 24 hours to move it, or we're going to take it. Not only did they take the money, he's in jail. Why? Commingling. You can't bring money from the private and put it in a public bank account.
Yeah.
OID money was private money. It should have been put in a private account. It shouldn't have been brought to the public. Never.
I agree. Thank you, Truth.
You're welcome.
Okay, next up, let's see here. Budman. Go ahead, Budman. Been unmuted. Go ahead, Budman. Hello, hello. Can you hear me?
I hear you fine.
Oh, thank God. He scared me there for a minute. Budman, I unmuted you. Let's see here. Hello? Are you there? Okay, well, we'll move on to Sal. Go ahead. Oh, wait. Okay, Sal, you've been unmuted. Go ahead. But you were unmuted.
Thank you,
Sal, there you go.
Thank you.
Oh,
How are you?
You're
how
welcome.
Are you again? How are you again, True?
I'm very well in yourself.
I'm fine. Thank you for asking. I just had a quick question. I'll let you go. For me to utilize the process of, for instance, your mortgage process or even maybe tickets, traffic tickets, will I have to actually become a private citizen? Will I have to do some kind of transformation, or can I just enter the court by a affidavit? Do you understand the question? Is there a process that I have to actually change over to enter this equity court to utilize, for instance, if I wanted to just donate tonight to get that process for mortgage or for just writing a ticket? Well, is there another step that I have to take?
Excuse me for interrupting. I never said at any time you can get the mortgage process for a $50 donation. Please do not make that mistake. I'm not giving that out for $50. No. Discharging a traffic ticket, I will give you the supporting case law. Remember, this call is for informational purposes only. I'm not telling you what to do. I'm providing you information. You have to put the information together. I could give you a template on how to do step A, B, C, and D. I'm not doing that. I'm giving you the information. You have to arrange it. You understand what I'm saying? You have all the pieces to the puzzle. I'm not giving you the puzzle assimilated. You have to assimilate it. Or assemble it. Let me put it that way. You got it? But you can't get the mortgage process or student loan process for a $50 donation. It doesn't work like that. I'm doing classes for the next 9 weeks, and it was a $2,500 donation to the Church of the Divine Light for the class, for the information that you're seeking. But a traffic ticket, it's a piece of cake.
But the process of being able to utilize it again, do I have to actually make a transformation to become?
No.
I have to be a.
No. If you want to deal with the public, I'll give you the case law and everything you need to deal with the public. The reason why I need to make this clear is because you cannot use law, statutes, and codes in equity. You can only use the 20 maxims. You cannot use any type of law in equity. That's commingling. You can't use equity in public court. That's commingling. That's why you have to say there's a conflict between law and equity. You can't commingle. So if you want to know how to do it on the public side, sure, I can help you with that. That's not a problem for a traffic ticket. But if you want to know how to discharge mortgages, car notes, student loans, etc., you really need to take the class because it's just too much information. And stop saying it's my process. Equity was here, before this country was formed in 1776. Equity was on the planet. I don't know if you ever heard my first example of what equity is from the scriptures. And that was, the example I used was the woman who was caught in the very act of adultery. That's how it's worded. I find that so interesting. How do you catch somebody in the very act unless you're a peeping Tom? I'm just asking. You know what I'm saying. So all these men bring this woman before Jesus and said, she's committing adultery, and what does the law say? And he kneels down and starts writing in the dirt. And he says, he who is without sin, let him cast the first stone. So everybody left, and it was just Jesus and the woman standing there. And he looked up and he said, woman, where art thou accusers? And they were all gone. Well, the equity of the matter is the injured party, which would have been her husband, is the only one who could bring the claim. You can't bring a private claim to somebody else in court without the power of attorney, conservatorship, or something like that. That's equity. There has to be a real flesh and blood injured party. Equity deals with people, not corporations. So does that help?
Yes, it does. Thank you for taking my call, my question.
Email me, and I'll send you there's a United States Supreme Court case, no license necessary. Well, if the United States, the Supreme Court of the United States says you don't need a driver's license, can any other court say you have to have one? Of course not. It's the highest court of this country. So no state can write a law to supersede the Constitution or federal law. Constitution man teaches that on Know Your Constitution. No state can write a law to supersede federal law. I run into people who say, well, I can't carry a gun because I'm an ex-offender. What law says that? Because it's not federal law. Federal law says the right of the people to keep and bear arms shall not be infringed. There is no subparagraph A, B, C, or D, and there are no stipulations to that. Anybody can carry a gun. The federal Constitution says so. The state says otherwise. I just told you the state cannot write a law to supersede the Constitution. Whenever there's a conflict, federal law always prevails. Whenever there's a conflict between law and equity, equity always prevails. The Constitution was meant to be an equitable trust document. Why do they always say you're breaching the public trust? Everything is trust law. It's not my way. It's how it is. I yield.
I use that term because the process is new to me, and it sounds like to many others. But I had another question. I don't want to hog the floor, but I did have another question. Your your status. I think you said that you were a private citizen. Is that correct?
Yes, I am, and so are you. It doesn't matter if you know it or not. You are.
Well, are you an established? Maybe I'm not understanding. Can you operate on the public side? Maybe I need to ask that question.
I do.
You do, even though
yes.
You're a private citizen. You can actually go back and forth.
Yes, I have two different entities. I have my private name, which I did a lawful name change in 2006, and I have my birth name, which I operate in commerce with.
I see. But as it stands for me now, I can't operate on the private side unless I go through a process of something. Is that correct or no?
Everything in commerce is done how? By notice. So if you're going to be a private citizen, you need to put them on notice. So that's the only way you're going to sever the relationship. And you do a declaration of status, a revocation of the power of attorney, because even though you don't have a mortgage, somewhere they got power of attorney when we did the Social Security application. So you need to do a revocation of power of attorney for that. You need to do an oath of allegiance to the United States of America and the unanimous declaration of independence and the state that you're residing in. It's called an oath of allegiance because private people make oaths. They do not swear. Your word is bond. So if you're giving somebody your bond, you're giving them your word. I yield.
I appreciate your response. I really have no more questions at this point, but thank you. I learned a lot. You can mute me out at this point, Angela. Okay.
All right.
Okay,
Thanks, Sal.
I'm going to share one thing, and this is really none of you guys' business, but I have credit cards. I don't have a bank account. But I have credit cards in the store name that I use to travel with because I need to book my flight. But, I know how to handle that. My lawful name change is Sadika Trvth. That's my lawful name change. And I did that in probate court in Mecklenburg County, North Carolina. But I am from Michigan. But a group of us went down to Mecklenburg because it was $50. In Michigan, I think they wanted like $250 to do a name change. But now I don't think it's that expensive. You can do a name change in 21 days if you so choose. That's what I chose to do. I'm not telling you to do that. That's what I chose to do. So I'm done.
Okay, well, there's a couple more people with their hands up. You want to take those?
Sure, I'll take them. I'll take them.
All right, then that's absolutely the end. But my son's guy is still here, so let's take a couple more. Go ahead, Akila.
Hi, Trvth. This is Aquila. Just wanted to say hello. And how you doing?
Oh, greetings. I'm very well. And yourself?
I'm blessed. Just working, but I'm good.
How may I help you?
Well, just saying hello to you. Just was listening.
Oh, thank you so very much for thinking of me.
You're welcome.
Thank you. There was somebody else with their hand up, and now they're gone, so I don't know what happened to them. Oh, well. Connecticut or... Oh, well. I guess that's it. Oh, wait. Budman has... Okay, go ahead, Budman. Sorry.
Yes, hey, Angela. Yeah, my phone hung up and it took my hand down. So when I called back in, I'm glad you said that because I didn't realize it. Trvth, yeah, that was excellent stuff that you were saying. Let's see. Primarily, I was wanting to make a comment back when Donaldson was on, and it was that one of the excellent proofs of this is the video that KW gave out about that was straight from the Federal Judiciary's Education Center, and it had coming straight out of the judge's mouths that you are a registered organization, and that it's the birth certificate, that establishes that. But as to his question as to how does it apply to you? Well, for me, as an example, I have 17 rental properties that they're trying to foreclose on. And so it applies to me because I want to try to keep my properties. I've got to fight for them, and I have to present as anyway, you've got to deal with that situation. But that I yield.
All right. Good night, beloved. Sleep tight. Until next time. Email me if you have questions.
Hello? Can you hear me?
Yes. Yeah, I hear you fine.
Oh, okay. Did Budman, was that it?
Yeah, that was it. Listen, I did want to say Donaldson, I love you, man. It's nice to know that people out there with your enthusiasm, are out there fighting the good fight, and you kind of get beat up on here sometimes. But, I appreciate the fact that you're out there and working hard, and I support you. It's a shame that more of us don't live closer together, that we could support each other in the courtrooms themselves,
Yeah. All right. Thank you so much. Okay. True. Thank you so much for coming on and spending over 2 hours with us. and sharing your knowledge and your wisdom, and I appreciate it very much. Thank you. We hope to do it again.
Okay, as soon as my internet comes up, I'm going to send you the documents that you should have had earlier.
Okay, and then I'll put them up on your page on our website.
Okay, you have a great and fantastic rest of the evening. Tell Joy I send my love as usual.
Thank you, I will. And to you, I send my love and a big hug. And let's do it again soon.
Okay, anytime. Anytime.
Right. Good night.
Right,
thank you so much.
Good night.
All right,
Mm-hmm.
Good night. Good night, everybody. Have a great weekend. We'll see you next time.